as we get back to our reporters there, a big development that is now coming in of the order copy from the Supreme Court that is now being accessed by Times Now, and we'll put out the key takeaways exactly when it comes to what exactly are the highlights and what came in the way for the both of the factions of the Shiv Sena. If we talk about Eknath Shinde and also Uddhav Thackeray breaking his silence for the first time, we're shortly expecting Eknath Shinde to also speak on the matter. Pranesh, the key highlights, please.
That's right. Telling our viewers about the takeaways. Let me now read the order verbatim. Point number 40, and in that subsection F, it says the decision of the governor calling Mr. Eknath Shinde to form the government is valid and cannot be called into question because, and then the court goes into reasonings. Mr. Thackeray resigned on 29 June 2022 without facing the floor test. On the resignation of Mr. Thackeray, it was the constitutional duty of the governor to call upon another person who commanded the majority in the Legislative Assembly to form the government, and Shinde staked his claim to form the government and subsequently proved his majority on the floor of the Legislative Assembly. Then let me go to point number 71. That has the conclusion, and that really sums up the argument in this case that has been going on for the last one year. Started on June 22nd when Shinde, along with 40 others, defected and said that we are no longer part of the Uddhav camp. Here it is, point number 61. To give quietus to the issue, we refer the following question and any allied issues which may arise to a larger bench, whether the issuance of a notice of intention to move a resolution for the removal of Speaker restrains them from adjudicating disqualification petitions under the 10th schedule of the Constitution. This is really the Namam Rebia judgment that the Supreme Court is talking about. The matter may be placed before the Chief Justice for appropriate orders. Let's go to point number 85. Amita, the point number 85 is crucial because under that, the court has listed the reasons as why it reached the conclusion in which they have said that, look, we cannot ask Uddhav Thackeray to go back as the Chief Minister because it was of his own volition that he chose to resign, and he did so without facing the floor test. Here's point number 85. The incumbent Speaker of the Maharashtra Legislative Assembly has been duly elected by the MLAs in terms of the procedure laid down under the Maharashtra Assembly Rules 1960. The petitioners have referred to the decision of the Speaker to cancel the recognition of Sunil Prabhu as the Chief Whip of Shiv Sena, to argue that the Speaker is biased and impartial. The decision of the Speaker to cancel the recognition of Sunil Prabhu has also been challenged in the instant proceedings. Even if this court sets aside the decision of the Speaker cancelling the recognition of Prabhu on merits, it would not be a sufficient reason for this court to decide the disqualification petitions. We are also unable to accept the alternative submission of the petitioners to direct the Deputy Speaker to adjudicate the question on disqualification. So the sum and substance really, and like we've been telling our viewers, that the Speaker, who is Rahul Narvekar currently, has to, within a reasonable time frame, decide on the disqualification petition. But I just want to make one last point, Amita, before I throw it back to you. Uddhav Thackeray is defiant. Even in the light of the Supreme Court order in which it is clear by the court that he can't become the Minister not until the next election. The Uddhav Thackeray says on moral grounds, Chief Minister Shinde and Deputy Chief Minister Fadnavis must resign because the Supreme Court has held that the decision of the Speaker to appoint Gogavle as the whip was illegal.
But where the court has held that the status quo cannot be restored now since Uddhav Thackeray did not face the floor test but voluntarily chose to step aside. We are awaiting and